This is topic 1 of land law. What is land? I will be lecturing from the notes which you should find on Moodle. So please make sure you have your notes in front of you as you are watching and listening to this. So what is land? We start with section 205. Subsection 1, Part 9 of the Law of Property Act 1925, which says, and you can find this in your notes, so I won't read the whole thing, that land includes land of any tenure, it includes mines and minerals, whether or not held apart from the surface, it includes buildings, parts of buildings, and so on, as well as other corporeal hereditaments, also includes privilege, benefit in or over land, and so on. So let's look at this. It's a very long definition of land. So let's have a look at the technical terms. As I said in the overview in the previous video, the overview to land law, there are a lot of technical terms in land law. So whenever possible, whenever any technical terms come up, I will explain it. So section 205 starts with land includes land of any tenure. So tenure just means either a freehold or a leasehold. As to what a freehold or leasehold is, this is something that we'll cover in the next topic. Yeah, right. So it also includes the words corporeal hereditaments. So what are hereditaments? It's an old-fashioned term meaning property which can be inherited. So hereditaments could be the corporeal or it could be incorporeal. So there are two types of hereditaments. It could be corporeal or incorporeal. Corporeal hereditaments are rights in land which are tangible, something that you can touch. So it includes the land itself, obviously, and anything on the land and in the land. So it would include buildings, it would include trees, plants, and so on, shrubs. Anything found within the land, in the land itself, in the soil itself, such as minerals and so on. Those are what we call corporeal hereditaments. So all of those could be considered land. Now, incorporeal hereditaments are rights in land which are intangible. And we have already come across this if you watched the overview of land law recording. And the one that the example that I've given in your notes is the right to use your neighbor's path, for example, as a shortcut to your property. This is a right of way or an easement. That's a technical term for such rights in land. And they're not tangible in the sense that, you can't actually point to that path in your neighbor's land and say, this path belongs to me. It doesn't belong to you. It actually belongs to your neighbor. But you do have the right to use it. So your right is an intangible right in land, which is an easement, and it is an incorporeal hereditament. So to summarize, the statutory definition of land includes not just the land itself, but anything on the land and any rights that you have been granted or given over that piece of land. So as I said, it also includes anything beneath the land, mines, minerals within the land. It will also include the airspace above the land. So as I said in the summary of the previous slide, That ownership of land includes not just the land itself, but anything within the soil of the land, mines, minerals, anything growing on the land, anything attached to the land, buildings, and so on. It also includes the airspace above the land. So let's see how true that is. There's a famous Latin phrase which starts with Caius est solum. You can see that on the slide. So what this translates as is the owner of the soil also owns everything up to the sky and down to the center of the earth. Now, that's not quite true. There are limitations. So let's have a look at the limitations. So if you own a piece of land, what do you actually own? How far up into the sky do you own the airspace, and how far down to the earth do you own any mines, minerals that are on your or in your piece of land? So we start with airspace. Now, airspace, there is obviously a need to balance the landowner's rights to use their land as they wish with the needs of the general public. So common law distinguished a landowner's airspace between the lower stratum and the upper stratum. So the lower stratum is what is required by the landowner to enjoy their land. The leading case, as you can see on the slide, is Bernstein against Sky Views. So a landowner is entitled to such height with regards to airspace as is necessary for the ordinary use and enjoyment of their land and any structures upon the land. So this is the lower stratum, and the airspace of the lower stratum belongs to the landowner. Okay. Now, the upper stratum airspace it doesn't belong to the landowner. So there are statutory provisions to that effect. For example, one that I've given you on the slide is Section 76 of the Civil Aviation Act 1982, which gives immunity from trespass to any aircraft that was flying at a height above the ground, which, having regard to the wind, weather, and all circumstances of the case, is considered reasonable. So this proves that the upper stratum of any airspace does not belong to the landowner, because if it did, for anyone who lives below the flight path to Heathrow, for example, you would be entitled to sue and claim trespass every time a plane flies over your property. Okay, so that's the limitation of a landowner's right to airspace above his or her land. So looking at the lower stratum now, what is a landowner entitled to if their airspace has been trespassed upon? So there are some cases that you can find on your notes, in your notes. The first being Kelson against Imperial Tobacco Company, where a sign advertising a product which projected 8 inches over the landowner's property, the leaseholder's property, was considered by the court to be trespass. So the landowner, in this case the landowner was a leaseholder, was able to obtain an injunction for the sign to be removed from his airspace. Okay. There's also Ellis against Loftus and Company to do with the horse's head being on within his airspace, and the court also held there that there was trespass. Okay, so that is the limitation. You don't actually own the airspace right up to the sky. You just own airspace for such height as is necessary for the ordinary use and enjoyment of your land and any structures on your land. That's Bernstein against Sky Views. So what about below ground? The Latin phrase says that if you own land, you own it down to the center of the earth. Obviously, not quite. The owner of the land owns the subsoil and the strata sort of immediately below it. Okay, so any interference by a third party would be considered actionable trespass. Anything that can be touched or worked must be taken to belong to the landowner. Okay, so the case you have in your notes is Star Energy against Bocado, where the court held that boring or drilling into someone else's land, even at substantial depths, is considered trespass. But there are limitations, obviously. If you look, and again, this is not part of your syllabus, so you don't need to worry too much about it. But any coal, any oil, for example, minerals found on a person's land doesn't actually belong to them. It actually belongs to the crown. Look at the Treasure Act. But as I said, it's not part of your syllabus, so you don't need to worry about it. That's all you need to know about ownership of land with regards to airspace and below ground. So we've looked at what a landowner actually owns if they own a piece of land. So now we're going to consider the physical objects that are placed on the surface of the land. And this, we need to look at fixtures and chattels. They're both technical terms, so let's have a look at the meaning. Now, a fixture is an object which has been physically attached to the land, so it becomes part of the land. A chattel is an object which is not part of the land, so it's considered personalty. So land, another technical term for land is realty, and personalty is anything, any possession that isn't land. Okay, so realty and personalty, these are two technical terms. So now that we know what a fixture or a chattel is, we now need to look at the tests to determine, to distinguish between a fixture and a chattel. The test is given in the case of Holland and Hodgson. It's a two-pronged test, two parts to it. The first part is the degree of annexation test. And with degree of annexation, the question to ask is whether the object has been affixed to the land. Okay, so it could be affixed in any way. It could be done using screws, nails, cement, whatever. Okay, if it has been fixed to the land, if the object has been fixed to the land, then prima facie, meaning on the face of it, it is considered a fixture, meaning it's part of the land. If it hasn't been fixed to the land, it's merely resting on the ground on its own weight, then on the face of it, prima facie, it is considered a chattel. So the onus is on the party who's seeking to prove otherwise. So how does this work? Well, so the burden or the onus of proof shifts depending on whether the object is fixed to the ground. So if the object has been fixed to the ground in some way, doesn't matter how, then as I said, on the face of it, it is a fixture. This means that the person who's seeking to prove that it is a chattel has the onus of proving that it's a chattel. Okay, so the burden lies on the person seeking to prove that it is a chattel. If, however, the object isn't fixed to the ground, it's merely resting on its own weight, then on the face of it, it is considered a chattel. So the onus lies on the party who is seeking to prove that it is a fixture. Looking at the facts of Holland and Hodgson, the objects in question here were spinning looms. They were nailed to the floor of a factory, and the mortgagees who were taking possession of the factory claimed them as part of the land, claimed them as fixtures. And the court agreed and held that the items, because they were affixed to the floor, they had become fixtures. Okay? So there's a shifting onus of proof, as I said here. The burden or the onus of proof always lies on the person who is seeking to prove otherwise. Yeah? So using the degree of annexation tests. If you look at your notes, there are quite a few cases. You have examples of how the court had decided. So, for example, in Hume and Brigham, heavy printing machinery which wasn't attached to the floor, they were held to be chattels. In H.E. Dibble against Moore, greenhouses were described as movable and considered to be chattels, but this is not always the case. Obviously, we know that there are some greenhouses which have become part of the land, for example, because they were cemented down or they were placed there as part of a design of that particular garden. They would be considered fixtures. So for that, we need to look at the second part of the Holland and Hodgson tests. So looking at the second prong of this test, which is the purpose of annexation test. And the question to ask here, this has to do with the motivations of the owner of that item in question. Was the object placed there, in that particular position, to improve the land, in which case it becomes part of the land, it's a fixture, or had the object been placed there to be enjoyed as a chattel, in which case it remains a chattel. Okay, so let's look at some case law. First case is Hampton Bygrave, as you can see, garden ornaments. So the guidance given by the court with regards to garden ornaments is that the purpose of annexation test is the deciding one. It should prevail over the degree tests, especially if looking at the way the objects were placed. It was placed there in the garden, for example, to create a landscape design, in which case it will be those objects will be considered fixtures, part of the land. And this was what happened in Dane Court and Gregory, the case immediately below Hampton Bygrave in your notes, Dane Court and Gregory. The ornament there was a stone seat as well as several marble statues of lions, which had been placed at strategic points in the garden to create a design. And the court held here that these ornaments were fixtures, not chattels, even though they weren't actually fixed to the land itself. But it doesn't matter that they're merely resting on in the garden on their own weight. The fact is they were placed there to improve the garden, and therefore using the purpose of annexation test, which is the deciding one, these objects have become part of the land and were therefore fixtures. Okay. By contrast, looking at the case of Barclay against Poulet, which again you can see in your notes, This has to do with a statue and sundial which were resting in the garden on their own weight. The court held them to be chattels because they were placed there by the property owner for their own individual aesthetic value, not as part of an overall garden design. Okay. What about tapestries? Now, tapestries are normally considered to be chattels. Okay, even if they have been tacked onto a wall, they're still considered chattels because tapestries, are usually tacked onto the wall so that they could be viewed and enjoyed. It's usually the only way that you can view and enjoy a tapestry. So even if they have been fixed to the wall, tapestries are usually considered to be or treated as chattels, not fixtures. Okay. Now, there's a case on wall-to-wall carpeting, that's LaSalle Recreations, but if you do a bit of research, you don't have to. Exam questions won't go beyond, what you have in your notes. But for every case you find on fitted carpeting or wall-to-wall carpeting where the court held it to be a fixture, there will be another case where the court has held it to be chattels. Okay, but in LaSalle Recreations, it was wall-to-wall carpeting. The question is whether the carpeting was considered fixture or chattel. But in this case, the carpeting incorporated a hotel's motif, and the court held it to be part of the hotel, and it's to improve the overall look of the hotel and therefore considered to be a fixture. Credit Valley Cable against Peel Condominium, television cabling, antennas, and so on. They're usually considered to be chattels, not fixtures, because even if they have been affixed to the wall, the point is that they were placed there not to improve the property, but so that the owner could better enjoy watching his television. Okay. A more recent case that we need to look at, which gives further guidance on more recent appliances and household items, is the case of Botham against TSB Bank PLC. It's a Court of Appeal case. So Mr. and Mrs. Botham sadly defaulted on their mortgage, which meant that the bank would take possession of their house and sell it, to recoup the loan. Okay. So the question here is what Mr. and Mrs. Botham were entitled to remove and take with them when they leave the house for good. And the Court of Appeal gave guidance on the things that they could remove and the things that they couldn't because they were fixtures. Okay, so the items here included fitted carpets, curtains, bathroom fittings, gas fires, kitchen units, and white goods, kitchen white goods, fridge, and so on. So first of all, the Court of Appeal in Botham held that the Holland and Hodgson approach is still applicable. The ultimate consideration is one of fact, so it's a question of facts. So the two-pronged test is still applicable, okay, and the purpose of annexation test is the deciding one. Okay, so the Court of Appeal held that kitchen units, bathroom fittings, and so on were considered fixtures, okay, because they were firmly affixed to the land and therefore in place so that the rooms could be used for the intended purpose, which meant they were placed there to improve that particular room. Carpets and curtains were considered to be chattels because in this case they hadn't been sufficiently affixed to the land, so couldn't be considered a permanent improvement. to the building or the rooms. Gas fires were considered chattels because even if they were attached to land, the attachment wasn't sufficient to cause them to be a fixture. Okay. White goods were chattels because even though they were required for use in the kitchen, they hadn't been sufficiently annexed, or the they weren't permanent enough to be considered fixtures. Okay, so the test given by Lord Justice Roche is that if the item, you need to view the item objectively. Was it intended to be permanent so as to make a lasting improvement on the building, in which case it becomes a fixture? If the attachment could be considered temporary and the attachment was no more than necessary for the item to be used as a chattel and to be enjoyed as a chattel, then it remains a chattel. Okay, so that is what you need to know about fixtures and chattels. Generally, if you were asked this in the exam, to consider this in the exam, okay, to consider whether an item is a fixture or a chattel, you would always start by using the two-prong test in Holland-Hodgson. You would explain each test, you would apply it, you would talk about if it's been fixed to the land and prima facie, what it is and so on. And the question, usually if it's a problem question, will also contain clues to tell you the motivations of the landowner, for example, and then you can use the relevant case law when you come to a decision, but it's not always black and white. So it needs you to discuss using the test, using the law, using the case law before you come to a conclusion. And whatever conclusion you come to doesn't mean that, even if your conclusion is different from someone else's, from the examiners, it doesn't mean that you're wrong. Okay? What is important is that you've used the case law and you've used it in support of your discussion, of your arguments. Yeah. Now, why do we need to distinguish between a fixture and a chattel? And you already have an idea as to why. Okay. It's because of Section 62 of the Law of Property Act 1925. Section 62 says that conveyance of land is deemed to include all buildings, erections, fixtures, easements, and so on, okay, or anything else that is enjoyed with the land. So what Section 62 is in fact saying is, if you have conveyed land to someone, so you've sold a house, for example, to someone, okay, anything that has been fixed to the land so as to become a fixture is included in the sale price. So the seller isn't entitled to, after they have exchanged contracts, to sell the land, when they're moving out, they're not entitled to take away items which are considered to be fixtures. Okay, to do so would be to breach the contract. Okay, which is why we need to know whether a particular item is a fixture or a chattel. If it's a chattel, the seller can take it away with them. If it's a fixture, they have to leave it. Okay. Now, to avoid any conflict, so obviously if the parties had entered into a contract to sell land and they didn't actually specify which items are fixtures, which are chattels, then obviously we need to go through the whole tests of the Holland and Hodgson test, degree of annexation, purpose of annexation, and so on. So to avoid any conflict, parties when selling the land, sellers and buyers, are always advised to use fixtures, fittings, and contents form. This is a standard form that you can download, okay? And what they do is, before they sign a contract, they agree between themselves as to which items the sellers would be taking away with them and which items the sellers would be leaving with the property as part of the sale price. Okay, so it's always advised that the standard fixtures, fittings, and contents form be completed and be made part of the contract when selling property. This will avoid any conflict, and there won't be any need for the court to go through the Holland and Hodgson tests. And that concludes the recording for the first topic.